Am I clearly audible? Hello, 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 hello. Yeah, s- am I clearly audible? Hello, hello everyone. Am I clearly audible? Hello, am I clearly audible? Hello, am I clearly audible and visible? Hello, hey everyone. Welcome to the current and legal brief. I am myself. I'm Dale Kamakhan. Ah, so we are going to start a journey of daily newspaper analysis. So before going to start, we will focus on certain things like yeah, you should know me, who I am, and you should actually know me. So my name is MDL Kamakhan. My name is MDL Kamakhan, and I am the founder. My name is MDL Kamakhan, and I am the former founder of Current and Legal Brief, a YT channel, YT platform. So I am actually a law student, educator, and content creator dedicated to make legal awareness, education, current affair, and constitutional knowledge accessible to every aspirant. So through my YouTube current and legal frame, through my YouTube, I simply try to explain complex legal theories into a simple method such that every person in country, whether it is he's a aspirant or not an aspirant, should learn, should understand what our constitution or what a rule or procedure mean to say. So I have started this January, and I have done my schooling with 10th with CBSE board, and my 12th is senior secondary school from Aligarh Muslim University, and completed this year. And now I am pursuing LLB from Aligarh Muslim University. So these are my background. You can read if you want. So my mission is, you see, to simplify legal education and current affair with clarity, authenticity, empowering every aspirant to learn, grow, and achieve their dream with confidence, integrity. So I began this journey with a vision that we will together rise from scratch to top of a mountain. So let's begin my journey. So today newspaper. Our first article is Free India. First article is Free India Indo-Pacific priority for India and Japan. Mm. As you know, as you know that on this is Japan president, Prime Minister Sanai Takachi, and she is the first female Prime Minister of Japan, and she came in India. And she is on an official visit into India, and it was her first official visit after becoming PM. After becoming a PM, so so यहाँ चल रहा है टेस्टिंग है. So this is the first official visiting of Sanai Takachi as the Prime Minister of Japan. Uh, we will focus this article in a legal analysis. So Indian and Japan relation. India and Japan is strengthening their strategic partnership to promote a free and open rule-based Indo-Pacific through defense technology investment and maritime cooperation. Key takeaway: India and Japan is trying to strengthen their strategic partnership through open and rule free and open and rule-based Indo-Pacific program through defense, through technology and investment and maritime cooperation. Some of the important takeaway of this article is that India and Japan reaffirmed commitment to FOIP. What is FOIP? FOIP is promote a free and open and rule-based program. It will help to gather the country. It will help the country to come together and try to make ties. Our 129 MOUs memorandum of understanding were signed between the nation in current visit of Sanai Takachi and PM Modi in various sectors like technology, AI, and manufacturing and investment. These are the 129. So you can assume that what are the level of MOUs that are signed. What are the importance of uh, what are the importance of Japan and Indian strategic partnership in this visit? And I think this visit has important and it can ask in our examination. So we will move to the next point of this article. Defense cooperation is important in Indo-Pacific region because of the China influence in the sea. Defense cooperation will deep through technology will be defense cooperation between the nation will be deep through technology in transfer and joint naval exercises. Japan has planned significant investment in Indian manufacturing and infrastructure development. Maritime security is a centerpiece of bilateral strategic cooperation. Maritime security is a centerpiece of bilateral strategic cooperation. This is the most important of the of this we can so it is a central part of this cooperation. So you can understand in this visit of Japan PM has the level of importance for India, and it is a significant because of these 129 MUs were signed in different field. So at present, you can see Indian and Japan relation is in a state where these two nation is emerging as a Asian power. Because for the Indian-Japan earlier relation and diplomatic relation began 1953. However, after 2014, special strategic and global partnership began. Major agreement you can see between the nation. 2026 strategic global partnership were signed in 2020. 2008 security cooperation and agreement were signed. 2011 CEPA comprehensive economic program were signed. 2014 SSGP were signed, and in 2015 bullet train agreement were made. Acquisition and cross service agreement and 2020 clean energy partnership were made. Some important military exercise between India and Japan are Dharma Guardian is the army exercise between the nation. JIMEX is a Japan Indian maritime exercise. It is a naval exercise, and in this visit, the central part of the Indian Japan meeting was how they will boost maritime security. Recursion is a Air Force exercise, and two exercises are where they both participate as a partner: Malabar exercise and a quad exercise. So this was the overall overview of this article, and you can understand what the importance of this visit to India. London Economic, or you can see here our 129 MUs were signed. See this. So I think currently India and Japan relation should should be significant for both nation. Because Japan gave us a technology in investment infra that can boost our economy and ultimately lead to a closer partnership in the age of what we can say in the age you can't have to say, age of war. We will move on to the next article. So we are going to move to our next article. So we will move to the next one. Another very important article of the day is Supreme Court quash an NCLT National Criminal Law Legal Tribunal. National Criminal Legal Tribunal. National Company National Company Law Tribunal of, after finding that it has fixes AI generated case law. This article mainly uh, focus on the AI in legal field. This article mainly focus on role of AI in legal field and maintaining the importance of uh, the uh, legal field. We will try to figure it out. We will focus on the there. Supreme Court NCLT order on AI generated fake judicial precedent. The important point of this article is how can a judiciary benefit from AI without compromising the authenticity, reliability, and integrity of judicial decision making? How can a judiciary benefit from AI without compromising the authenticity, reliability, and integrity of judicial decision making? सुप्रीम कोर्ट बोला सुप्रीम कोर्ट ने आदेश दिया वो सुप्रीम कोर्ट rejected an national company law tribunal NCLT order. Supreme Court rejected NCLT order because उसने relied it was relied AI generated fixes judicial precedent means they are made too much AI generated case laws like if you search on ChatGPT that I wanted the important case on regarding like uh, uh, driving cases like drunk and driving cases there are certain amount like or driving cases so what it will do it will generate some fixes judicial precedent, cases law that are not important, that are entirely fabricated, but but it appear to be important. But actually it is fabricated and it can't tell you the importance. Therefore, Supreme Court has specified zero tolerance zero tolerance policy toward fake or hallucinated legal authorities. It also stated that AI may assist legal researches but cannot replace judicial reasoning or verified legal sources. Court has clearly mentioned that however, AI may replace judicial AI may assist legal research but cannot replace judicial reasoning or verified legal sources. And later it means next one it means Supreme refer to the draft regulation for use of AI. Supreme has made a draft regulation for use of AI in courts in 2025. According to this draft, according to this draft, it is emphasized AI should function only in a assertive capacity, not as a legal researchers. It can only as assertive capacity, not to draft any um, then any draft any legal articles document. You can only take a assertive just to help, and it is important because ethical responsibility of judge and lawyer in the age of AI. It is important to maintain ethical responsibility of judge and lawyer in the age of AI. Free, so the entire of this the entire article is iota of fake hallucinated material in decision making. The iota of fake entered into a decision making procedure. It would violate the sanctity of addition in necessary to maintain integrity in decision making. And we reiterate DC declare zero tolerance on bar as well as a bench to side refer such method. Another important article of the day is 20 passenger held with fake visas at Hyderabad airport. 20 passenger held with fake visa at Hyderabad airport. They stopped in Oman Flight and 39 accused were filed against FIR was filed against 39 accused, including 99 and 19 travel agents. Consider the rule of so you will understand this article try to understand this article. Oh, fake visas is we are witnessing fake visa. How this system is the system weakness. If the system is weak, these things will come definitely. So, the breakdown of article 20 passenger were intercepted at Hyderabad airport while traveling with forged document. Where this forged document come from? Obviously, the agent will give. But and the police registered case on 39 accused, including 19 travel agents. Police has made a registered case against 39 accused and including 19 travel agents. How did the passenger reportedly believed that they were traveling legally and were allegedly misled again by the agent. These are the allegation of passenger to agent. Therefore, police has filed a case on anti-agent. It highlights now these issue highlight illegal overseas recruitment. Um, in a there is no illegal overseas recruitment. Well, anywhere anyone can come, anyone can come and go in India. Anyone can enter India and enter and exit India without official oversight. I think it is a main concern for the government. And, document forgery is important, crucial issue for our country. And because of this, it is actually a national threat to the our country. Weak regulation. Weak regulation is important for the important weakness of this. Uh, we can say due to weak regulation, uh, these type of cases we hear. Rise of human trafficking and labor. There is a concern of a human trafficking and a labor exploitation. So I think we have to focus on effectiveness. Immigration check is also at a speculative or doubtful nature. Therefore, strong immigration screening and essential for safe and legal migration. Recruitment agency require stronger regulation and accountability. Most of these things, our image at an international level is declining, and we have to tackle this by how we will tackle it. Screening, strong immigration screening, essential for safe and legal migration. Requirement recruitment agency require stronger regulation and accountability. Got it? To our next article. Well, our next article is PF rule notified no vote on hike in minimum pension. The Ministry of Union Labor Ministry published on June 29 that Employee Profile EPF Scheme 2026 and Employee Provision Pension Scheme 2026 and the Employees Deposit are to be what the important breakdown of this article will breakdown. Let's see the breakdown of this article. PF rule notified no hike. PF rule notified no hike in minimum pension. PF rule notified no hike in minimum pension. The union government has notified new rule for EPF in Employee Provision Fund, Employee Pension Scheme, and Employee Deposit Linked Insurance. Employee Deposit Linked Insurance under the Code on Social Security 2019. Trade union criticize absence of any increase in minimum pension under EPS. आपने तो ये रिलीज कर लिया लेकिन एक एम्प्लॉय एक मिडिल क्लास एम्प्लॉय जो मेन इम्पोर्टेंट पेंशन आपने इतने इन्फ्लेशन है उसे बढ़ाया नहीं. This is the main cause of a trade union. You can see the EPF, Employee Provision Fund, uh, Employee Pension Scheme, Employee Deposit Linked Insurance (EDL). The Employee Provision Fund is managed by Employee Provision Fund organization established in 1952 under the Ministry of Labor and Employment. The main concern of the worker or trade or union is reforms. The government has initiated the reforms, but the reforms try to fail to address the worker biggest demand increase in minimum pension under the EPF. But the government failed to increase the minimum pension under EPS. We see rising inflation and cost of living have made current position of worker inadequate for many trainees. They can't even the survival of at today basic things commodities prices significantly increase. Then how a worker is able to survive in this age? The government failed to address a worker problem. The gap between labor welfare exception, expectation and government reforms increasing the gap between labor welfare expectation and government reforms increasing. And it raises an important serious question whether social security reform should be practiced should prioritize administrative efficiency or improve quality of life of labor. This is the main concern of this article. Like any government or any organization, security forms, as any organization should prioritize their administrative efficiency or improve quality of people. If your goal is to improve quality of people, the government must should address the worker um, important serious issue like their increase their minimum gap, minimum pension, but they don't increase. Then what we can see their gap between uh, uh, the gap between labor welfare expectation and government significantly increase, and therefore the protest is soon begin anywhere in the state. We will focus on next on important article is that article. We will focus other important article of the video. Right to fair trial at the crossroad. Right to a fair trial is a crossroad, and this is the most important article in the legal eyesight to be decoded. We will decode this article tutorial, and it is important tutorial for Latin and latest especially this article has many what we can say case laws, and then there is a constant this article has a constant issue between UAPA or what we can say. I will explain it in better way. Overall I will saying this article has a important uh, what we can say important variation like UAPA versus personal right to personal liberty and equality. We'll break down this article in our decode about this article. So here is the article: right to fair trial at the age of crossroad. The constitutional right. Look at the question. Look at the concept behind this. The constitutional right to fair and speedy trial is being undermined. The constitutional right to be the constitutional right to a fair and speedy trial is being undermined by prolonged incarceration without conviction, particularly under the stringent laws such as UAPA. आप यूएपीए को एक टूल्स बना के किसी पर्सन और इंडिविजुअल को आप एन नंबर ऑफ टाइम्स उसकी बेल को डिनाई करके उसको लॉन्ग कस्टडी में रखते हैं, आप उसको जेल में रखते हैं बिना उसको उस पे कोई एक्शन लेके, ना उनको अपने ट्रायल में भी नहीं ले जा रहे हैं। आई थिंक इट कॉन्स्टिट्यूशनल, you are murdering the constitution. However, overall, Supreme Court has examined it really examining Supreme Court inconsistent approach to grant bail in a long pending criminal cases. Supreme Court has trying sometimes they are trying to sometimes they are approaching inconsistent approach to they do not grant bail in some pending criminal cases. One famous cases you heard about like Delhi riot case in which Umar Khalid and Sarjil Imam were uh, is under the custody from last 5 years. Even they are only just accused, not proven guilty, and even they did not get a single trial. And they are their bail is constantly denied. I don't know why they are doing so. So we are this important. Can a state continue to keep an accused person in prison for years without completing their trial? If yes, then justice delayed is just we know already. State cannot keep people behind bars for years without trials. Cannot. You are attacking their fundamental right. Article 21. You cannot keep any person behind bars. Cannot, bro. You cannot. Bar. Editorial argue that would to prioritize constitutional right over procedural rigidity. Now, important question prevail whether constitutional right prevail over procedural rigidity. UPA already it is stringent act. If you ever get in this और ये आप अगर इसके एक्ट में आप फंस गए तो then it's very difficult to get bail. However, the bail is granted, but it's very tough. I know endless imprisonment without trial raise urgent question about justice. Endless imprisonment without trial raises urgent question about justice. How how can a state has power to that they can keep imprisoned without trial? Urgent question of this right to speech trial is an inseparable part of Article 21, and Article 21 we already know is a fundamental right. You cannot. But what happening is today we can see they are murdering the constitution. Hussaina Khatun versus State of Bihar in 1979. Supreme Court clearly held that right to speech trial is an integral part of Article 21. Article 21 is what? Right to life and personal liberty. Right to speedy trial is also a integral part of Article 21. National security law cannot merely extinguish constitutional safeguard. Yeah, I know national security is priority, but you cannot. I repeat, national security law cannot merely extinguish constitutional safeguard. Although UAPA contain stringent bail provision, and it's nearly impossible to get bail provision under UAPA Section 43D5. Subsection 5. However, Union of India versus K. Najib in 2021 judgment, Supreme Court held that prolonged incarceration can justify granting bail despite their restriction. But you are not against judicial consistency. Rule of law. Judicial consistency is essential to the rule of law. Similar case should receive similar treatment, otherwise it create uncertainty among citizens, and they will ultimately lose the trust on the judiciary. Special law like UAP cannot become instrument for indefinite pre-trial detention. Uh, government cannot use UAP as a tool to criticize to uh, um, for indefinite period to what we can say. Okay, government cannot use UAP as a tool किसी को धमका के आप किसी को like you cannot गवर्नमेंट के नॉट धमका नहीं सकते आप इसको आपको उसको राइट को वायलेट कर रहे हैं उसको बेल नहीं दे रहे हैं then it is an important constitutional crisis we are saying judiciary has the constitutional duty and the guardian of the is Supreme Court to ensure the criminal trial conclude within a reasonable time and that incarceration does not become punishment before conviction. Yeah, if the person is guilty or convicted, then you can keep them under behind the bar. But in a person is not convicted, then merely speed trial is at stake. Further article to be remembered, Article 21, right to life and personal liberty include fast, uh, speed and fair and speedy trial. Article 14 include equality before law. Article 22 safeguard against arbitrary arrest and detention. So this was a today breakdown of the article. We will focus next day with another video, another daily. We will focus on the next day. Today is our first day, so we have given a short video so that we will come again next day. Next case. So for today, thank you and do like if you find do like and subscribe if you think it's helpful for you. This is the first class of today. Thank you.